Okay, there. Well, good afternoon, everyone, and thank you for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have attorney Chase Wells presenting for us. If you are unfamiliar with the format of this event, first, Chase is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Chase to get us started.
Thank you so much, Marissa. I appreciate that. Again, my name is Chase Wells. I'll just introduce myself very quickly and then get into the content. I've been an attorney for over 15 years. I've always practiced in Western North Carolina. I'm from Western North Carolina in the Appalachian Mountains. And I did a variety of law for about 10 years. I graduated from Wake Forest School of Law. And for the last 5.5, I've been with Legal Aid. It's been fantastic. We help low income individuals and families with various civil needs. And it's been very fulfilling for me to do. And I'm happy to present on landlord tenant law. It's primarily what I do these days, is representing tenants in small claims and district courts. We'll talk about all the ins and outs of that. So let's get started. Yeah, just a shout out to other things that Legal Aid does and other listens and learns. So sessions just like this, if you have any of these issues, know anyone who has any of these issues, it's a good place to get information on child custody, criminal record expungement or expunction, that's erasing a criminal record if eligible, Medicaid rights and eligibility, simple divorce, meaning uncontested divorce. You can even find form packets or do-it-yourself on things like that. SNAP benefits, also known as food stamps, Social Security disability, tenants' rights we're doing today, and wills and powers of attorney. So here's a quick roadmap. Who is a tenant? It's not as easy of a question as you would think. The eviction process we'll talk about from start to finish. Repairs and rent abatement is probably the most common issue or defense that tenants have, and we'll talk in depth about that. And lastly, we'll talk about security deposits, which are taken typically at the beginning of a lease and then dealt with at the end. So who is a tenant? Tenant is someone who has a residential lease with the owner of a property. No requirement that the lease be in writing, but there must be some kind of exchange for someone to be a tenant. So the typical situation, a tenant goes to someone who owns or who manages a property. Could be an apartment complex, could be someone who just owns an extra home that they're renting out. But the primary landlord in the situation is the owner of the property, and they can give authority to an agent or a property manager or a power of attorney in some circumstances to handle the details of rent and day-to-day operations of that property. So the easiest way to know what a tenant is to also talk about what a tenant is not. So a guest is not a tenant. A guest would be someone who's invited to a property. There's no exchange of money or services or any other item of value, and no particular time frame for the stay. So a guest is not a tenant and therefore does not have the benefit of the landlord-tenant procedures under the law. A guest who, or anybody else who has not been given permission to stay at the property or has been told to leave is one of two things. They're not a tenant, but they could become a trespasser, and a trespasser can be removed by either a criminal or a civil action for trespass. So if someone has no sort of agreement, oral or written or otherwise, and is simply essentially squatting on the property, then that person could be taken to criminal court and charged with trespassing. There is a very recent new procedure for it's called a squatter's law, and it is a civil case that's sort of in between the sort of bright line rule of tenant versus trespasser. The squatter is a very quick procedure. We haven't seen a lot of them yet because it's very new, but it is at least a civil case and not a criminal charge being brought. But that's not something we're going to cover today. But we're focusing on tenants who have some kind of agreement, some sort of arrangement, doesn't have to be formal, with the owner of the property or manager. There has to be some kind of exchange. Now, typically that is rent in the form of money, but it could be otherwise. Sometimes you will see leases where the tenant is doing some kind of work, either on the property or working at the landlord's business, or maintaining the property. Sometimes you'll see caretaker services, things of that nature. But if there is an exchange of something of value to the owner of the property, then a lease has been created, and the tenant is a tenant and not a guest or a trespasser or a squatter. As far as hotels, there is a law that was passed in 2023 that if a person stays at a hotel room for less than 90 days or 90 days or less, they are not a tenant. After a person has stayed consecutively more than 90 days, then they may be a tenant if there is essentially an agreement. And an agreement, a lease agreement, can be implied by the conduct of the parties. So a lot of times, even if no words are said, but the tenant is making regular payments, the landlord is accepting those payments, and whatever potential agreements they may have come to, that can create a lease. So the eviction process, this is where the landlord, the owner of the property, or the manager has decided that the tenant should go. So the first thing that they need to do is provide a notice, and we often call that a notice to vacate. It can be called a notice to quit, a notice to terminate, termination of tenancy. It can go by a lot of different names, but it is some kind of information communicated to a tenant that says it's time to go on a certain date. So this is important. A landlord must go through the court process before having a tenant or the tenant's belongings removed from the residence. So just in general, when we're talking about eviction process, these are things that a landlord has to go through. Okay. So I'm going to spend just a second talking about self-help eviction. The self-help eviction is when a landlord does anything other than going through the legal eviction process through the court system and filing an action for eviction, or summary ejectment, as it's called. So the self-help eviction, some examples. The most extreme would be if the landlord walked in and forced a tenant out the door and locked it behind them, changed the locks. That's a self-help eviction and it is illegal. If you're in that situation, I would recommend contacting counsel as soon as possible. Sometimes contacting law enforcement can bring results to restore the tenant back while the landlord goes to the legal route. There are claims to be made against landlords who do attempt self-help evictions. So that is something to, again, contact counsel about, legal aid, or other. Another example that's not quite as clear is landlords who may attempt to cut off the power or cut off water or any other utilities, or otherwise just kind of make life miserable for the tenant Though depending on the behavior and what it is, those can be considered self-help evictions. They're outside of the scope of the eviction process laid out by North Carolina law, and that is illegal. Uh, Typically, what will most likely be done by the tenant or an attorney is to file a case against the landlord and ask for a temporary restraining order and a injunction, which is a court order, to turn the power back on, turn the water back on, or whatever needs to be done to restore the tenant back to the regular tenancy um, until such time as the landlord follows the law for eviction. Summary ejectment only applies to tenants, right? The other types of persons living in a property, guests, trespassers, or squatters don't receive these protections, okay? Hotel guests don't receive these protections until they've been there over 90 days and have established a landlord-tenant relationship. The tenant will receive a summons and complaint. And I will go back once because I didn't elaborate on the notice to vacate. There's a couple of things I need to say about that. The notice to vacate has to be clear. Okay. There are court opinions saying that it can't be something that says from a landlord that says, tenant, it's time to start thinking about leaving, or you need to make other arrangements. It has to be clear. It has to say that the tenant needs to leave by a certain date. Um, and we'll talk about the notices the dates a little bit more specifically here. But it does have to be clear and it does have to be communicated. Now, it can be oral in an oral lease. Okay, if there's no written lease, then the landlord can communicate that orally. It can be done by text, email, or other forms of communication. If there is a written lease, sometimes the lease will specify that that notice has to be a certain way. Sometimes it will say it has to be mailed to a certain address or certified mail or have certain particular language or be sent in a certain number of days before termination of the lease. So one thing that you will hear me say a lot today is read your lease. If you've got a written lease, read it, get familiar with it, and read it carefully because the lease language can determine one way or the other on a lot of different issues. So assuming well, maybe the landlord hasn't given a notice or has, but when the landlord chooses to, they can go to the courthouse or they can go online through the courthouse website and fill out a complaint and a summons. The complaint tells the tenant why they're being evicted, and if the landlord is asking for any money in the form of rent or damages of some other kind, it will explain that. It's a form that the landlord fills out. The summons is another form that the clerk of court fills out, and that gives the date and time for the hearing. Tenant may receive notice of the hearing by being handed copies of the complaint and summons by the sheriff. The landlord can also inform the tenant about the hearing by posting a copy of the complaint and summons on the tenant's door and sending another copy through the mail. So typically the way this is done is the landlord files, and within either that day or the next day, the sheriff will be out to the property to try and hand the notice to the tenant directly. If the tenant is not available, then the sheriff's deputy will tape it or affix it somehow to the door of the rental property. Usually the case is heard in small claims court in front of a magistrate. 99% of cases of eviction go to small claims court first. These things can be very quick. So if the tenant is handed the complaint and summons, then the hearing can be as soon as 2 days later. So if you're handed a complaint and summons for eviction on Monday, then there could be a hearing on Wednesday. Typically, the courts will set them roughly a week out in places, counties or courts where the dockets are backed up. It may be longer, but they are designed by the North Carolina laws to be pretty quick as far as getting to small claims court. So let's talk about the substance of eviction. Why could a tenant be evicted? And the law limits the reasons to only four. Now, each one of these four has a lot of sort of subcategories and reasons and different types of defenses, but there's four main categories or reasons why a tenant might be evicted. And the first is the most common. It's non-payment of rent. If the tenant has failed to pay rent, or at least the landlord alleges that the tenant's failed to pay rent, then that tenant can be evicted. The second is holdover. We're going to talk about each one of these in detail, but I'm just going to give you a broad overview right now. Holdover has to do with the lease term ending, right? So if a tenant has a lease for 1 year beginning January the 1st of 2026 and ending December 31st of 2026, then come January 1st of next year, 2027, if the lease hasn't been renewed, then that tenant is a holdover. So this is assuming the landlord has terminated the lease and hasn't renewed, then the tenant is a holdover. Same thing goes into month to month. If it's for the month of March, the landlord and the tenant are not renewing for April. On April 1st, the tenant becomes a holdover. 3, breach of lease. This is where a landlord claims that the tenant has violated some particular term of the lease agreement, or something that was agreed upon has been breached. And then fourthly is criminal activity. So those are specific North Carolina or federal crimes committed on the property. We'll talk about that. So the first reason, non-payment of rent. Tenant's rent is late. The landlord has made a clear demand for the late rent, and the landlord has waited at least 10 days for the tenant to pay the amount owed before filing to evict. So this is for oral leases or leases without default clauses. We'll talk a little bit about default clauses. Again, read your lease, okay, and also know that not everything in a lease necessarily is legal. Okay, North Carolina sets certain limitations on what can and can't be in a lease. So just because it's in the lease doesn't mean that that is the way it has to be. But as long as it's within the boundaries of what North Carolina law allows, then the lease is going to control. So the lease could control, for example, the method of payment. Should it be made through cash or a cash app or Venmo or through money orders or things like that? If it's agreed to by both the landlord and tenant in the lease, then that is valid for how the rent is paid, the date on which it's paid, the date on which it's late. Again, so a good example of something that North Carolina law regulates. If the landlord says that rent is due, but I'm going to charge you a late fee. It's due on the 1st, but I'm going to charge you a late fee on the 2nd. Well, that can't be done because the law says that a late fee can't be charged until it's at least 5 days late. So that's an example of that. Now, important to know that for non-payment of rent, the landlord has to give a notice. Okay, again, that can be oral unless the lease says it needs to be written. Typically, and I advise this to anyone in a landlord-tenant agreement, do put things in writing, and that can include email or text, just something that's verifiable that it's been written down and communicated. But the landlord does have to send a notice to the tenant and communicate in some form, and then wait 10 days. Okay? And that 10 days is a time for the tenant to catch up. After the 10 days, so on the 11th day, the landlord could go ahead and file. If the landlord doesn't wait the full 10 days, files on the 9th day, then that eviction ought to be dismissed in the small claims court for failure to give a notice, wait 10 days before filing the complaint. Um, Once the complaint is filed, there is an option for tenants to, it's what's called tender. Tender is essentially the same thing as catching up on the rent. But once the landlord has filed a complaint and summons, they've paid court costs for that. They've paid typically $30 per person to the sheriff. Then the tenant, if the tenant wants to catch up at any point at any point up to a judgment by the court, the tenant can pay all the past due rent uh, and the court costs, which would be the filing fee and the service fees. Okay, so it's typically filing fee of $96 and then a service fee of $30 per person. So they would add that on to whatever rent is owed. And the best way to do that for a tenant in that situation is to have a money order, bring it to court, and that way it's done in a public forum in front of the judge. The judge is then required to dismiss the eviction. Now that may hopefully, landlord and tenant after that can go on with a good relationship. But if not, it's there may be issues the following month. So talk about holdover now. Holdover happens when a tenant remains in the residence after the lease is ended and proper notice was given that the lease would be ending. So again, this is the example of, say, a 1-year lease for all of 2026. If it comes 2027 and the landlord has given a proper notice, then the tenant has to be out at the end of the year. If they're still there, they're holding over. This type of eviction doesn't have to have a reason. And this is especially hard for a lot of tenants to stomach, because say in a month-to-month lease, where a landlord terminates the lease at the end of any given month, they don't have to have a reason. I've seen situations where tenants have lived in the same property for 10, 15 plus years on a month-to-month basis, and they've paid their rent every month. There's been no problems. But for whatever reason, the landlord's decided to terminate the lease. And this has been the tenant's home for a very long time. And they want to know, why can I be evicted? Well, the landlord doesn't have to have a reason. They don't have to state a reason. And typically when they go to court, they won't state a reason. They will simply present the notice that says, I hereby terminate your lease. So let's talk about the notice. Second bullet point, the lease states a specific way the notice must be given. The notice must be given in that way. Again, read your lease, especially any paragraphs that have to do with notice. The minimum notice requirements depends on how long the lease is. If it's a year lease, it's got to be 30 days before the end of the year. If it's a month to month, at least 7 days before the end of the month. And if it's a week to week, at least 2 days. Now, the lease itself may require more. A lot of leases will say a 30-day notice has to be delivered, even though it's in a month to month. So again, this is an example of North Carolina says has to be at least 7 days notice. If the lease says 5 days notice, well, that won't work in a month to month because it has to be at least 7. But if the lease says more than that, if the lease says 30 days notice, then it has to be 30 days. A quick point on counting days, and this actually applies to any law anywhere. When you're counting days, and let's say you're counting 5 days, you start with the day after something happens. So, for example, if the landlord gives a notice on Monday, that's not day one, that's day 0. So Tuesday is day 1. Wednesday, Thursday, Friday, Saturday is day 5. Okay. So you always start day 1 the following day. And that can become important, right? Because if, let's say in a 30-day month, we'll say November is 30 days, the landlord would have to give the notice to terminate at the end of November. They'd have to deliver that notice to the tenant by the 23rd. The 24th wouldn't cut it, but the 23rd would. And then the last bullet point here, if the landlord accepts rent after the lease ends or signs a new lease with the tenant may have a defense to the holdover eviction. So we'll talk about this again when we talk about breach. But in, let's say, a month-to-month situation, every time, think of it as a new lease every single month. Think of it as the lease terminates at the end, or doesn't really terminate, but it ends at the end of one month, and then it renews at the beginning of the next month. So if a landlord gives a notice to a tenant and says, I'm ending this tenancy at the end of November, come December 1st, the tenant pays rent, just ignores the notice, pays rent, the landlord accepts that rent, then there's a new lease for December. It's a new month. It's called novation, is the legal term for it, but you've essentially renewed the lease, and that is a defense to the eviction. So in an eviction filed, and I see this fairly often, where a landlord will file, let's say in December, and the tenant's already paid December rent. Well, it's too early to file eviction. There's already a valid lease going for the month of December, so that eviction should fail in court. Breach of lease. So we're now on the third reason out of four for an eviction. Tenant has violated a condition of the lease. Well, what is that? Well, you'd have to look at the lease. If let's see, just and I'll talk about this in a minute. There is a big difference here for oral leases versus written leases. Okay, written leases, it's easier to see and read what the agreement is. What terms are there? Are pets allowed? Is the tenant allowed to sublease to a different tenant? Is smoking allowed? Is what things are and are not allowed on the property? Okay, and that is, if it's written, it's easy to see what's in the lease agreement. So if a lease says no smoking inside the unit, and the tenant smokes, then the landlord could evict and present evidence to the court to show that smoking occurred, and therefore that's a breach of the lease. In an oral agreement, though, that's a little tougher to determine. So sometimes it can end up as a he said, she said scenario, where the landlord and the tenant say, well, we had a discussion at move-in, and we talked about smoking and that it was not allowed. At that point, it's up to the judge to determine if smoking, if there was in fact an agreement on no smoking or not. But there has to be a term of the lease for there to be a breach. Okay. And if we're talking about something that is not in the lease, not in a written lease, and not discussed and agreed upon verbally by the tenant and the landlord, then there's no term to breach. Okay. So if the landlord and tenant never talked about animals, never wrote down anything about pets or animals at the property, and the tenant brings an animal to the property, there's no breach of lease because there's no lease term to be breached. Okay. The next thing that's important is for a lease to have a forfeiture clause or right of forfeiture. Now that's a legal term, and it the term itself reads like legalese, but what it says is that if the tenant breaches any of these terms of our agreement, then the landlord has the right to evict the tenant. Okay. Now, why is that important? Well, it's important because if that's not in the lease, then the landlord doesn't have the right to take back possession of the property. They do have the right to sue the tenant for money damages. Okay. So, for example, using the animal, let's say a tenant brings an animal into the property. The lease says no animals, but there's no forfeiture clause. Okay. There's no clause in the lease that says that a breach of the no animal clause allows the landlord to take back possession of the property. So if that's the case, then the landlord could potentially go after the tenant for money damages for any damage that the animal may have caused, but could not take back possession of the property because the lease doesn't allow them to. So you can see here again how an oral lease, a verbal lease, may be different here because there's not going to be a forfeiture clause in an oral lease. I mean, I suppose it could be proven that the landlord and the tenant got together and they discussed it, and it was made very clear that if A, B, C, or D happens, that the landlord has the right to take back possession of the property. But that's going to be difficult to prove if it's just verbal. Almost all leases, especially if it's done by a lawyer, if it's a form lease or one that comes from a legitimate legal source, they're all going to have a forfeiture clause built into it. But occasionally they don't. Most non-payment cases are brought as breach of lease cases. And this is more of a technical thing I'm not going to really get into, but sometimes you will see non-payment as a breach of the lease because payment of rent is a term of the lease. If the tenant's breached that, then it would entitle the landlord to eviction. A lease may waive notice. Some leases may require it. So again, a written lease can have specific terms in it about notice in the event of non-payment and may reduce that amount. So if we were going back to, again, holdover, that's different, right? We've got the 30 days for a year lease, 7 days for a month to month, 2 days for week to week. But in a breach of lease case, well, you simply have to look at the lease itself. And if it doesn't have a notice period, then there may not be any notice period required at all. Yes, most tenants in subsidy programs, public housing, project-based Section 8, other types are entitled to notice. So we're not going to talk about specific subsidies and types of leases that are subsidized by different governmental programs. But if you are in one of those, if you have a Section 8 voucher, if you're in a property that is USDA rural housing or a project-based Section 8 property, again, don't worry too much about knowing all those. But if you are in a situation like that, just know that there are specific rules for each type of subsidized property, and you can usually find those online. A lot of them are federal rules. If you look at the federal laws or HUD regulations, you'll be able to see what specific things are required. So not just notice, but a lot of different other types of things are required by the federal rules and that's a little more complicated than we can go into today. But just know that it's there if you're in one of those situations. The complaint will describe the breach, and then in a court hearing, the parties could argue over whether the tenant's alleged activity occurred and whether that was a breach of the lease. So the fourth and final reason that a landlord might choose to evict a tenant is for criminal activity. Violations of the North Carolina Controlled Substances Act or other criminal activity that threatens the health, safety, or right of peaceful enjoyment. Just to talk a little bit about what that means, not every single crime is a valid reason to evict. For example, if you dig into the law on this, simple possession of certain types of controlled substances, simple possession does not form a basis to evict under this part of the law, but manufacture or sale does. Most crimes that affect the peaceful enjoyment or safety or health of other folks that are in the area of the rented unit. So, assaults, and other types of crimes that could have an effect on other people living nearby or effect on the property itself. And certainly injury to real property, things like that can result in an eviction. Another important limitation on this is it has to be a crime that occurs on the property or in the vicinity of the property. Okay, so if it's something that was if it was some type of criminal activity that occurred 10 miles down the road, then that's not going to qualify under the criminal activity laws for eviction purposes. Now, that's completely separate from any criminal action that may be going on. Another important thing to know is that it does not require a conviction. Okay. So, an eviction for a criminal activity occurring on the rented premises, an eviction can be filed and can go forward even before a criminal case has been finished or even started. Okay. Um, there is a different legal standard. So many of you have probably heard the standard for being convicted of a crime is beyond a reasonable doubt. And that's a fairly high standard to meet. In a civil case like summary ejectment, it's a slightly easier standard. It's what we call preponderance of the evidence. It's kind of a more likely than not. So uh, typically, if a landlord has some evidence, they do have to have some evidence that a crime occurred on the property. But if they present that evidence, they won't have to go to the extent that a prosecutor would have to convict someone of a criminal case. It's just something to know. Um, Statute allows for expedited eviction. As I said earlier, the small claims process is very quick. They can be filed, served, and a hearing within a week. We're going to talk about what happens after that. The whole process can get extended significantly from there. But the small claims part of it is fast, and it's the same for criminal activity as well as any other type of eviction in small claims. The difference comes in when we start to talk about appealing the small claims judgment to a higher court, to the district court. And in that situation, the eviction for criminal activity is expedited or quickened. Tenant can be held responsible for the actions of other household members and guests. Okay, so if the tenant is inviting people who are breaking the law on the property, then that can be a cause for eviction. There is a potential for partial eviction where only the person, if there's multiple people at the property and only one or not all of them are involved in the criminal activity, it can be a partial eviction of just one or two tenants or not all of them. A conditional eviction is something that if the situation calls for it, um, the person who is not committing any criminal activity can be charged that or essentially it's ordered. It's like a court ordered agreement, sort of, that person is not going to allow the offending criminal back onto the property. And if they do invite them or allow them without, contacting law enforcement or seeking, seeking otherwise to keep the offender away, that they could be evicted in the future. So we've gone over the four legal reasons why a landlord might choose to file an eviction and how they could proceed on those. So let's talk about some defenses to that. One is being a victim of domestic violence. So we just talked about criminal activity. If there's an assault by, let's say, two tenants are living together, one tenant assaults the other, the victim is victim of domestic violence and files for protective order, then the victim can't be evicted for that, unless they also did their own independent criminal activity or some other breach of the lease. They could not be evicted simply because they're a victim of the domestic violence. Now, the domestic violence perpetrator could certainly be evicted. Waiver is a common defense. So landlord accepting rent after an alleged violation of the lease waives the right for the landlord to be able to terminate the lease based on that violation. So this happens when, let's say, again, let's go with a lease that has a no animal clause. Okay. And the tenant brings in an animal. So there is a breach of the lease. The landlord knows about it, is fully aware. And come the following month, the landlord accepts rent and hasn't said anything about the animal. Well, then that constitutes a waiver of the breach. Okay. So this has to do with timelines. So there has to be a breach. The landlord has to know about it, and then rent is paid and accepted. Okay. Now, that doesn't work on criminal activity. You don't waive for that. And it doesn't work if the lease has a no waiver clause in it. So if a written lease says that acceptance of rent is not a waiver of any breach, then you can't use that defense. Invalid notice. This is a big one. In this, invalid notice is one of the most common defenses that is usually the easiest to prove and works a lot, especially in small claims court, is that the notice is insufficient, right? So if it's a 10-day notice for non-payment of rent, the landlord gives the notice but files on day 9, then that should be a quick and easy dismissal of the eviction, because those are hard rules. Those are, black and white rules on the notice. If it doesn't terminate at the end of a month, right? So if we're talking about the holdover, let's say it's a month to month, again, think of it as a new lease for each month. A lease for January, a lease for February, a lease for March. So if a landlord decides, well, I'm going to give a notice in the middle of the month for a termination date in the middle of the month, well, theoretically that should fail in court because the lease is for the entire month and the rent's already been paid and accepted. So you can't terminate it in the middle of the month. You'd have to terminate it at the end of the month or the end of whatever period the lease is, and then file the eviction after that. Failure to offer a reasonable accommodation. This one, this is pretty complicated stuff. We're getting into the Fair Housing Act and things like that. So a good example of that is, let's say a tenant's income is disability. Okay, they're receiving monthly disability payments, and they get the payment on the 3rd. Well, the landlord wants payment on the 1st, but the tenant doesn't have the money until the 3rd. So the tenant asks for a reasonable accommodation as a disabled person for the ability to pay rent on the 3rd instead of the 1st. That would be an example of a defense based on reasonable accommodation. The Fair Housing Act also goes into support animals and things of that nature, which can be used to protect people in certain classes and disability, marital status, gender, race, national origin. So any protected category of persons can ask for specific things. A lot of times it has to do with disability accommodations, handicap ramps, things of that nature. Things. But we won't go into that anymore. But just to if you feel that there's any kind of discrimination involved, you would want to look into Fair Housing Act and reasonable accommodations. If the amount claimed is wrong, so especially in non-payment of rent cases, there can be an argument between the landlord and the tenant over what is owed. I'm going to talk about this. A lot of landlord-tenant situations arise because there's no clear record of what has been paid and what has not. So I do recommend that anyone and everyone use some kind of verifiable payment system. So an electronic payment system is great, like Venmo or PayPal. Those keep records. They're hard to fake, and it's clear what's been paid and when it was paid. Checks are fine because you can get a record from the bank that shows the check when it was cashed. Money orders and cashier's checks, a little tougher to prove just because you have to go through a process to get the record showing that the money order was cashed. And things like Western Union will charge you a big fee just to give you those records. Um, but the problem arises when the rent's paid in cash and there's no written receipt. Okay. If cash is going to be paid, then there needs to be a receipt. And if there's no receipt, then hopefully there's a witness or perhaps a conversation through text messages about the rent. Sometimes it can be difficult to prove, um, again, what rent was paid and what was not. So do it in such a way, if you're able, pay rent in such a way that it is verifiable what you've paid and when. Another defense, failure to make a demand for possession before filing a lawsuit. The way the law is written, so we talked about four different reasons for eviction. The first three, so non-payment of rent, holdover, and breach of the lease. This doesn't apply to criminal activity, but for the other three, the law is written in such a way that even after the notice has been given, the landlord still has to demand possession of the property. So let's do this in a holdover example. The landlord gives is in a month to month lease. The landlord gives the tenant 7 days notice before the end of the month. The following month comes up, the tenant's still at the property. Then the landlord is supposed to make one more demand, and that again is just communicated in some way to the tenant that I want possession of the property back and you have to leave. I will just tell you that this defense works in some counties and doesn't in others. Okay. This is something that is not the clearest, but it is supposed to happen if you read the law carefully. The landlord is supposed to make this additional demand for possession of the premises. But I will just tell you that a lot of judges in some places sort of don't read it that way. Tenant did not know or have reason to know that the criminal activity was occurring. So if we're talking about a criminal activity, when again, you know, where multiple tenants are concerned, one tenant doesn't really know what's going on, and they can convince a judge that, look, I didn't know, I didn't have a reason to know. There was this other tenant in a different bedroom. They did everything, kept their door closed. I didn't know what was going on in there. Then perhaps that tenant can be protected from eviction, but the other would not. So the small claims court hearing. Um, Magistrate typically rules immediately right after the landlord and tenant have said their piece. They don't have to, they can reserve judgment. Sometimes if you hear a magistrate say, I'm reserving judgment, then they're going to mail it to the parties within the next few days. The magistrate's ruling is called a judgment. Judgment is not final for 10 calendar days. So the 10 days is a waiting period, and the landlord cannot go forward during those 10 days. So if the landlord is successful against a tenant in small claims court, they have to just sit tight for 10 days. And it won't be until the 11th day that they could proceed with the next part, which we'll get to. During those 10 days, whichever party was unsuccessful in small claims court has the right to appeal it. And they're appealing it to district court. Okay. District court is a higher level of court. Just there's three levels. There's small claims, there's district court, and there's superior court. And most evictions start in small claims, and if they're appealed, they end in district court. They can go on up from there to the Court of Appeals. Very few cases do, but it is a possibility. So again, either party can appeal. So the landlord could appeal. More often tends to be the tenant appealing. So let's say the landlord gets a judgment for eviction. During the next 10 days, the tenant decides that they want to appeal it. Well, there's documents that you fill out in their court forms, and you can get those forms from the courthouse in person. You can look them up and download them online. don't think the website's on here, but it's nccourts.org is where you would download. That's nCcourts.org. You can also on the NC Courts website use a handy wizard. It's called Guide and File, which helps you fill out appeals and potential counterclaims, things like that. And if you need help, you can always seek counsel from an attorney. But there are two documents that are necessary for it. One is the notice of appeal, and the other is a bond. The form's called a bond to stay execution of a summary ejection judgment, or a rent bond. Okay, rent bond is what we call it for short. Rent bond is important because if a tenant is going to appeal a case from small claims court and they want to stay in the property, right? They haven't left and they need to be able to stay in the property, then rent has to be paid during that time. The difference in it is that instead of paying rent directly to the landlord during the appeal process, they pay it at the courthouse. Okay. And just FYI, they only accept cash or certified checks. So no credit cards or other types of payment. It's got to be cash or certified check. There's more specific rules on rent bond that would take too long to get into today. But just know that if you're in a situation where you're appealing from a small claims court, the rent has to be paid to the clerk. If the case is appealed, the case will be heard in district court de novo, meaning the hearing will start fresh and the tenant will have a new chance to argue the tenant's case. So de novo is a fancy Latin phrase meaning new, that nothing that happened in small claims court gets the district court judge is not going to know. You're not going to have a recording or a transcript or anything of the small claims court hearing. It's a brand new hearing. You start from scratch, right? So the written padlocking process. So this is what happens if the case is not appealed. So if the landlord gets a judgment for eviction in small claims court, the 10 days have passed, and after 10 days, on day 11, it becomes final. And another thing about counting time and days is if that 10th day lands on a weekend or a holiday, it rolls over to the next business day. Okay, so if the 10th day happens to be New Year's Day, then it would roll to the second. And that again, that goes for all deadlines. Anytime you're counting days for any kind of court process or a legal deadline of any kind, it rolls past holidays. Again, court holidays, right? This is North Carolina court holidays, and weekends. It rolls to the next business day, court day. So the 10 days have passed after the eviction. There's been no appeal filed. Then the landlord can get a writ of possession. Okay. And when the writ of possession is finished, they can get the locks changed. So a writ of possession, what is that? It's an order signed usually by the clerk of court. It's an order to the sheriff to remove the tenant from the property. So I will tell you in practice, at least in my area, again, Western North Carolina area, the writs of possession, once they're filed, the sheriff will typically they will mail a letter. Once they're filed, it tends to be about 7 days out, usually about 1 week out, when the sheriff will come back. So the sheriff will make 2 visits. So once the writ of possession, which is taken out by the landlord, once that's filed, the deputy will make a visit and either hand that writ to the tenant or post it on the door. That writ, and typically the sheriff will put a letter with that says the date and time they're going to come back. Okay. So, and it's usually a week out. The sheriff is going to come that second day, and it will be a very short period of time. But at that time, the sheriff's deputy will ensure that the tenants leave the property. Once the tenants have moved out of the property, um, at least physically, their persons have walked out of the unit, then the landlord could change the locks so that it could not be re-entered. We'll talk about personal property in a second. Well, I guess we'll talk about it right now because it's the next thing. The writ will be executed by the sheriff ordering the tenant to leave the premises, uh, and any of the tenant's belongings that are still in the unit will be padlocked inside. So a tenant has 7 days after the padlocking to set up a time with the landlord for the tenant to get the rest of the tenant's belongings. So if it's come this far down the line and the tenant has still not moved all of their things out of the property, they have to contact the landlord and make arrangements during reasonable hours to move the rest of the things. So anyone who is being evicted, excuse me, I always advise them to, move out as many of your things as possible into somewhere new, into storage, into friends and families. Throw it away, donate, do whatever you got to do to get things out before the writ of possession is executed. Because after that, it can be difficult sometimes to make arrangements with the landlord, especially if it's been sort of hot. A difficult relationship um, at that point. So it's best if you don't have to take advantage of this 7 days, but it is there if needed. A tenant will only have 5 days if the remaining belongings are worth less than $500. And it's so hard to say what the value of personal property is that in most every situation, the sheriff's deputies and the judges sort of just default to the 7 day window. Landlord's duty to make repairs. Okay, so this is a common one. Let's talk about what a landlord's duties are as far as the property and what a tenant's duties are. Landlords must obey the local housing code if there is one. This is something to know. A lot of towns and cities have specific housing codes. Some places don't. Some counties have housing codes, some don't. So this is something you have to look on the websites typically for your town, your county, and see if there's any specific housing code and what it requires. The landlord has to repair dangerous conditions in a reasonable time. Dangerous conditions, unsafe floors, lack of potable water, drinkable water. Those are examples of really dangerous things. A huge hole in the floor, um, you know, uh, rat infestations. Some of these things can get pretty bad. I've been in some pretty rough apartments. But if it falls into the category of imminently dangerous, then it's got to be repaired quickly. Keep common areas safe, right? Hallways, stairwells, driveways. Keep electrical, plumbing, sanitary, heating, and other facilities and appliance in good and safe working order, right? So, the sinks and the tubs need to work. Heating is a big one, especially since we're in the winter. If the heat, there has to be some heat source, right? There's not required to be more than one, but it has to at least keep the apartment above, well, more than freezing, I forget exactly, but there is a temperature that it needs to be able to keep the apartment up to during the winter. Install smoke and carbon monoxide detectors. Those are required, both a smoke detector and a carbon monoxide detector. These duties cannot be waived or avoided by the landlord. Okay, so there's one limited exception, but uh, the general rule that almost always applies is that the landlord cannot write a term in a lease that says, I'm not responsible for the heat. That's on you. Buy your own space heater. They have to provide heat for the apartment. Okay. If and as far as things like appliances, It's whatever the landlord agrees to provide in a lease or has provided when the tenant moves in. So if there's a microwave, that's part of the apartment, then the landlord needs to fix the microwave. But if the landlord didn't provide a microwave, well, then that's going to be on the tenant. If they want a microwave, then they're welcome to bring one in. But whatever appliances and fixtures that the landlord provides or agrees to provide, they need to maintain those. The tenants must continue to pay rent unless given permission by the court to withhold rent. This can frustrate a lot of people. Different states do this differently. Okay, some states allow a tenant to withhold rent, some or all of the rent, when repairs have been requested but not made. Okay, North Carolina is not one of those states. Okay, the rule in North Carolina is that a tenant has to continue paying the rent each month, and then the tenant can file a lawsuit, a small claims action, or a district court action against their landlord for return of some or all of that rent. We're going to talk more about that. It's called rent abatement. When a landlord fails to uphold their implied warranty of habitability. So that when we're talking about this, there's the legal phrase is the implied warranty of habitability. So your apartment has a warranty. It's implied by the law. And the warranty is that your apartment, rental unit, house, trailer, whatever it may be, is habitable, that it is in a fit and habitable condition. That doesn't mean that it has to be perfect or pristine. It just means that it can't fall below the minimums of housing codes, or other conditions that the law specifies. Tenant can consider contacting code enforcement for inspection. In some places, it may be a health department. Some places, it may be a town or city department that does inspections. So wherever you are, whichever code enforcement or health department covers your area is who you might contact. If you have a Section 8 voucher, Section 8 voucher holders, there are inspections regularly for those. So you might contact the housing authority that manages your voucher for that. And as I said earlier, you can bring a lawsuit against the landlord. Ask for rent abatement. So you're asking for a portion of your rent back, or perhaps all of your rent back. And you can ask for the rent to be lowered going forward until the landlord makes the repairs. So what does this look like? You're asking the court to look back, okay? And you're asking the judge to look back and examine each month that you've paid rent. And let's say, for even numbers, the rent was $1,000 a month, okay? And the tenant has given notice, and this is something I forgot to mention, always give written notice, okay? Either on paper, email, or text, something that's verifiable as to what you said and when you said it. But give notice to your landlord of what needs to be done. Be respectful, but give notice. And you're asking the judge to look back for each month after which you gave notice to the landlord of a problem and the landlord did not fix it. So let's say to start with 1 month, there was 1 month when the water only worked in a third of the house. Okay. So what you'd be doing is you would ask the judge to discount the rent for that month for what you believe is a fair number. Right. Now, the rent's not zero because everything else in that, let's say everything else in the house was okay, and you still had water enough to get by. so it's the value, the fair rental value for that month is not zero, but it's not the full thousand either. So to be honest, it's kind of a guessing game, and you want to give a reasonable number that a judge can get on board with and say, I think that's a fair compensation to the tenant for the problems. Now, when I encounter a situation where the landlord has cut off power and water, or locked the tenant out, then I say, yeah, the rent should have been zero for those months. You can't charge rent when and this is a rule of law that the landlord can't charge rent when it's completely and utterly uninhabitable. Okay. It's not supposed to happen. So, especially if the tenant's been kicked out, obviously they shouldn't have to pay rent if they've been unlawfully kicked out. But in situations where there's no power, no water, or really, really, really bad conditions, we'll argue that the rent should have been zero. But where it's somewhere in between, then you just try to give a fair guesstimate. You could potentially have a real estate rental agent, or someone who's familiar with market values of rent, come and testify, to talk about value, because what you're asking for is the difference in value from the rent that you paid to what rent you should have paid, based on the conditions of the apartment. A lot of this is guesswork. I'll just be honest with you, but that is the legal remedy for lack of repairs. When anytime you're filing either the appeal or filing your own case against the landlord for rent abatement, you're going to want to ask the clerk of court or get it online. You're going to want the petition to sue as an indigent. Indigent's a fancy word for poor, or unable to afford the filing fees. It can save you the filing fees. And in a rent bond situation, if you're appealing, it can save you certain portions of past due rent for that. So anytime you're filing anything, if you are low income, or don't believe that you should be charged the filing fee, you can fill out the indigency petition, give some financial information to the clerk, and they'll determine if they're going to waive the filing fee for you. A rent abatement claim can be a counterclaim to a claim for eviction based on a tenant's failure to pay rent. So I know I told you that you still have to pay rent and then sue your landlord. But more often than not, this comes up in a situation where someone a tenant withholds rent because of conditions that have not been repaired. So the landlord files an eviction for non-payment of rent, and then the tenant brings a counterclaim, right? So they've been sued in small claims court and they file a counterclaim against the landlord for rent abatement. It can be done that way. I will just warn you that in some places, in some situations, that can be a roll of the dice, because sometimes judges will give because if the landlord, let's say, is asking for $500 worth of rent, okay, and you file a counterclaim against the landlord for more than that, but the judge disagrees with you and gives you less than $500. The judge gives you any less than $500, the eviction's still going to go through. Okay, so there's risk to withholding rent, and then filing the rent abatement claim as a counterclaim to an eviction. Rent abatement evidence. So yeah, if there's any inspections, you're going to want copies of the reports. You want to show where you made the request for repairs. So by text, email, letter. If you have a app or a portal, that can be good evidence. Make sure you take screenshots or make printouts of any requests for repairs. You're going to want to take pictures or video. And you can use testimony from other people in the household, from an inspector, from anybody who has good information or knowledge about the conditions. The better picture you can paint of how bad the situation was in the courtroom, then the more likely the judge is going to abate the rent, and the more they're likely to rule in your favor. I know I've kind of already talked about, you know, the money amounts here. The official way to look at it is that it's the difference between the rental home as warranted and the actual fair market value because of the conditions. So typically the rental value as warranted is the amount of the monthly rent. But each condition or each month that those conditions lasted uh, reduce the value of what would be fair market in those conditions. So, but the tenant can testify as to their opinion of what that is. The damages are limited to the amount of rent actually paid. Okay, so um, if a tenant asks for 3 months of rent back, but only paid 2 of those months to the landlord, well, the landlord will only be required at maximum to give back 2 months of rent. So if you haven't paid it to the landlord already, you can't get it back in a rent abatement claim. So in a situation where no rent's been paid, the landlord files for non-payment of rent, the tenant comes back with the counter. There's no money exchanged there. Even if there is, even if the judge decides that the tenant doesn't owe anything, there's no judgment for money to be exchanged in that situation. I hope that made sense. A tenant can also ask for consequential damages. So in a situation where a landlord cuts off power and the tenant has to go elsewhere to take a shower, to um, a hotel room, bottled water, if the water's out, things of that nature. Keep receipts for all that, because those amounts can be recovered in a judgment from the court. So for a tenant, tenant breaking the lease, the tenant is bound to the terms of the lease. This includes any terms regarding early termination of the lease by the tenant. Again, read your lease, whatever it says, most likely is going to be the rule for your situation, but there are some things to consider. I typically recommend, if a tenant needs to break a lease, to have a candid discussion with the landlord. And I say that for most things. And, in general, folks, talk to each other, communicate respectfully and truthfully, and you can resolve a lot of issues just by communicating. In fact, in many circumstances, even if things have already gone to the courtroom between two parties and they are at odds with each other, I still open a line of communication, talk to the other side, and just see, is there any compromise we can reach that everybody can live with? Um, I recommend that in all situations. A lot of times, just going to court uh, and coming out of the gate guns blazing is not always the way to go. So I do recommend in most situations, not everyone, but in most situations, if you can work things out, it's better to at least try. Um, so if a tenant needs to break the lease, uh, maybe the landlord will agree to it and let him go. Great. If not, they don't have to agree to it. Domestic violence exception. So victims of domestic violence do have the right to break a lease early and leave if that's what they need to do. They also have the right to change locks. If they choose to do so and if they're staying in the apartment, they can change the locks. There are exceptions also for military. So if you get deployed and have to leave, you can break a lease early under certain circumstances. But you do have to give notice. You have to at least notify the landlord ahead of time. Tenant can be held responsible for the rent through the end of the lease term, sort of. The landlord has a duty to mitigate damages. So what does that mean? That means you've got a 1-year lease, okay, and the tenant needs to leave 3 months early before the end of the year. The landlord could potentially file suit against the tenant for 3 months worth of rent. But if the unit sits vacant for 1 month and then finds a new tenant for the last 2 months of the year, then the most the landlord can get is 1 month's rent. Okay. So the landlord has a duty to mitigate, which means try to re-rent the property. So in most situations, landlords rarely go after tenants for the rest of the rent during the lease term, but it does happen. And in today's market, when there's so many people looking for rentals, that rentals tend to get re-rented almost immediately after they're vacated. If you've been looking for anything, you know how difficult it is and how fast it moves. Um, So let's talk about security deposits. So this is after a lease has finished, and this is however it ends, right? If the landlord and tenant part ways on good terms, or it ended in an eviction and a writ of possession and all that, and there's been disputes, lawsuits, all that. A landlord still, regardless of how it ended, the landlord has 30 days after the tenant vacates to either return the security deposit or provide the tenant with an itemized list of deductions. So for this reason, it's important that when a tenant leaves a property, they leave a forwarding address so that they can receive their security deposit. Um, but by law, the landlord must either send the money back from whatever security deposit was deposited, or they send a letter that lays out an itemized list of what that security deposit was spent on. And there are specific laws. This is all under Chapter 42 of the North Carolina General Statutes. And there's a Tenant Security Deposit Act. It says what can and cannot be taken out of a tenant's security deposit. Normal wear and tear cannot be deducted. And as you can probably imagine, there's a lot of argument over what is normal wear and tear and what is beyond normal wear and tear. But that's a case by case basis. Um, if the tenant owes rent, then the deposit can be used to pay any owed rent. It can be used to pay for damages to the property. Um, it can be used to pay certain fees, any legal fees. If the landlord doesn't return a security deposit or doesn't give a letter itemizing what that deposit was spent on, then the tenant has a right to sue for return of it. Okay, so if you've waited the 30 days, and the landlord can get an extension of 30 more days, that is mentioned in there. But if you've waited enough time and the landlord hasn't returned the security deposit, hasn't given the reason for not returning it or what it was spent on, then the landlord forfeits the security deposit. So the tenant can bring an action again in small claims court is typically where that would be to get the security deposit returned to them. In some situations where the landlord is just willfully withholding the security deposit, you can even get attorney's fees for that if you hire an attorney to do that. Um, Yeah, and then another thing that's interesting is in a lease or even a verbal lease, the landlord is supposed to identify the bank where they're holding. It's supposed to a security deposit is supposed to be kept in a separate account, right? It's not supposed to go in with the landlord's other money. So they're supposed to identify to the tenant where that money is held. So a lot of times, if a lease doesn't have that in there, then the the security deposit can be retrieved or ordered from the court. And there towards the end, if the landlord sues in small claims court and gets a money judgment, the security deposit can be used for that judgment. If a tenant sues a landlord for return of the security deposit and the tenant owes rent or the landlord counterclaims, a money judgment could be entered against the tenant. So, I mean, this is kind of a general rule that whenever you sue, there can be counterclaims. Okay. So just be aware of that. If you sue for rent abatement, right? Back to the habitability problems, conditions of the apartment. But the landlord could potentially countersue and say, well, yeah, but you damaged the counters or, did something else and ask for damages for that. So if you sue for security deposit, there can be counterclaim. If the landlord sues you, you can counterclaim. So anytime you're in court, that claims, any claims that two parties have against each other can all be aired out in the same lawsuit. So just be aware of that. So that concludes everything I have to say, and I will be able to take some questions here. And I will tell you that um, if you're hearing this session, you've probably already found Legal Aid of North Carolina's website. I'm an attorney with Legal Aid of North Carolina. Um, the website is great. If you go to the Get Help section, there's all kinds. There's videos from the past talking about this and other areas of law. There's manuals. There's guides with forms. There's all kinds of stuff on the website. We even have an AI chatbot, Leah, LIA, that is free legal information, and can help direct you to what kind of things you need, give you, answer basic questions. And if you're in a situation where you might qualify for legal aid services and you need help and you feel like you need further representation or at least legal advice for an attorney to look at your case specifically, you can call the legal aid helpline. If you're 60 or older, you can call the senior legal helpline. Um, if you want a private lawyer or you wouldn't qualify for legal aid financially or for whatever reason, you can call any local attorney that you find, or you can use the North Carolina Lawyer Referral Service. That is a database that directs you to attorneys who've signed up for it and agreed to take or give consultations, $50 for a 30-minute phone consultation. So that's if you feel you need follow-up help. All right, I'll be ready to take some questions if we have any.
Awesome. So again, if you have a question, you either need to type it into the Q&A box on Zoom or put it in the comments section on Facebook. You cannot unmute in this forum. So if you have a question, you need to type it in to one of those two places. Also, before we get in questions, as Chase was talking, I did put in several links into the chat, including if you are interested in applying for assistance from legal aid to avoid having to wait on the phone. I put the link to our new Justice Hub portal where you can apply online at any time. And then to get into our first question, does the landlord have to send a 10-day pay or quit demand for every month that rent hasn't been paid, or can they only send it once?
Uh, it's a waiver, so they do have to send it every time. If a landlord says, "Well, I'm owed rent," they send a 10-day notice, and the tenant catches up. Well, that covers that month, and then next month, if the tenant's late again, then the landlord's got to send another notice. Wait 10 days, go again. So no, if there's been an exchange of rent, then there's got to be a new notice.
And then I guess the follow-up is, what if the tenant hasn't paid rent in any of those months? Like,
Oh, in any of those months, um, then most likely the notice, if it was given and it says what it needs to say, which is you either pay this money or you have to leave and you have 10 days. If it meets those qualifications, then that's probably still valid, I would think.
okay.
Would you
If
agree?
I would actually,
Yeah,
I would
yeah,
that one notice is probably good enough if there's been no change in the several
yeah,
months.
yeah.
Um, if a landlord loses in court, I'm assuming in a situation where there's been unpaid rent or some other fee, can the landlord still charge the late fee? So that's an interesting question, I think.
Hmm. I don't think so, because typically if a landlord sues for uh, an amount of money and they lose, Most of the time, the judgment of the court is, if they don't appeal it, it's final, right? So if a judge has looked at this case and determined that the landlord is not owed this money, well, that judgment is, in the Latin phrase is res judicata. It means what is decided is decided. So the judge has decided that landlord was not owed any rent. So I don't think they can bring that up again later. Now, of course, rent is going to be, due fresh and new every month. But for any months prior to the judgment being decided, I think that's settled.
And well, follow up to that one, I guess charging legal fees, like maybe like a complaint filing fee or something, in a situation where the landlord was not successful at the eviction.
No, and this is something that, Marissa, we might want to think about putting into the PowerPoint. Is authorized fees. Uh,
Hmm.
so I wouldn't mind talking about that for just a second. Yeah, I think we've got a little bit of time. Um, North Carolina authorizes certain fees and does not authorize other types of fees. So, um, if you're talking about the complaint filing fee, it's a very narrow scenario that kind of fee is allowed. The complaint filing fee is a fee that's allowed where a landlord files for eviction, and gets it, or they work something out, and then for whatever reason, the landlord still they don't follow through with the writ of possession, and the tenant continues on, and they renew their lease. Okay, so they've gone to court, the landlord's been successful, but they've moved on. Then the landlord is able to add that fee to the client's balance, going forward. But again, that's a very narrow situation that doesn't happen all that often. I do want to talk about late fees. Late fees are very important. The late fees are, by law, cannot be charged until the rent is at least more than 5 days late, and it can't be more than 5% of the monthly rent. Okay, so um, if if a landlord charges more than 5% of the monthly rent as a late fee, if that's in a lease, that provision is void. And the law doesn't reduce that. Let's say a landlord's charging 10%, that doesn't get reduced and all of a sudden the landlord gets the 5%. No, it's the whole term is void. There is no late fee. Okay, so if it's more than 5% of monthly rent, that term is void. And it can also result in some debt collection counterclaims against the landlord that can carry fairly serious monetary penalties. So that's something to keep an eye out for. There is a statute. I think it's called authorized fees and costs. It's within Chapter 42, the landlord tenant
Hmm.
chapter, North Carolina law, and that lists the specific fees that can and can't be charged.
Perfect. And I'm actually gonna have answer this one. For the person asking about how to find eviction information, since the filing of an eviction is public, I am putting a link to the portal system, North Carolina courts portal system. All counties in North Carolina now utilize the e-court systems. So things like evictions for all counties you should be able to find that online. The second part of this question that Chase, you may be able to respond to is in a situation where someone is a victim of domestic violence and maybe is seeking to change those locks that you mentioned, do they have to, work with their property management company to change the locks, or can they just do that themselves?
I'm not sure I remember exactly. As long as the property manager is not part of the problem, then I would recommend communicating with them about it. But I believe that it can be done uh, as soon as it's necessary, and then come back on the back end and deal with any uh, fees, fines, or not fees, or the costs of doing it. Um, I'd have to look that up. I could probably look that up real quick.
Okay, hold on. To the
Yeah, it's chapter 42, section 42.3.
And while he's looking that up, because I see more questions asking about fees that are kind of along the lines of what Chase just explained, I am putting a link to that section. So it's chapter 4246 in North Carolina General Statutes regarding eviction fees. I'm putting a link to that specific PDF here so that you can look over, to see what kinds of fees are, kind of strictly approved by the North Carolina law. Mhm.
Yeah, so it's a little more nuanced on the lock changing. So you are supposed to give a notice to the landlord and ask them to change the locks. Um, but they're supposed to respond and change the locks within 72 hours. If they don't respond and change the locks within 72 hours, then the tenant can do it themselves. Um, but they do have to provide a key to the landlord. The tenant is responsible for the costs associated with that.
Perfect. So I think that answers the only other question I'm seeing at the moment. I'm not sure what this person is necessarily referring to, but I'm thinking they're asking, what if someone receives a 10-day notice, and those 10 days, and within those 10 days, another rental payment is due? How would they approach? And I'm assuming this is the non-payment eviction box one type
Yeah,
situation.
yeah,
How would they
yeah,
approach that in terms of paying before an eviction is filed?
yeah. I think they're probably asking, like, from a practical standpoint, should I be paying rent if I'm going to get evicted, or they've given me a notice uh, for last month, and now the next month's due. Um, the rule is, if you're going to catch up, you've got to catch up all the way. Okay, so whatever's due. All right. So if you're catching up the rent and it's after, the first of the month, um, but you've got some balance left from last month, you've got to catch it all up at once. And that's the way it would work if the eviction is filed and you're going to tender the rent and the court costs in the courtroom. Then you've got to do the whole amount, right? There's no partial, unless you come to some agreement with the landlord, which again is, especially if you're in a situation, if you can't pay it all, a lot of times landlords will say, okay, yeah, if you'll pay me half now, I'll give you a few more days to pay the rest or whatever. I would communicate on that if you can, and if not, then it's kind of an all or nothing, pay the full balance.
Perfect. Well, as I am not seeing any more questions, I'm going to go ahead and say thank you to all of you for joining us, with a very special thank you to Chase for presenting for us. If you would like to review anything that Chase talked about today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access the recording on Facebook with or without a Facebook account at www.facebook.com/legalaidnc. The recording will only be available for about 30 days, so if you need to watch it in the future, you will need to go to Legal Aid's YouTube page and click the Listen and Learn playlist. If you would like to register for one of our other Listen and Learn programs, such as Medicaid rights, simple divorce, child custody, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their afternoon.
Thank you, Marissa.
Thank you.